We will start on with panel number 2 now, which is based on the dynamics of international energy, power, and gas disputes. I would request the moderator for this panel, Ms. Leonora Reisenberg, who works at 45 Gray's Inn Square as a chartered arbitrator, an accredited mediator, and a certified ADR practitioner, and she will be discussing her thoughts on resolving energy disputes, lessons from global best practices. Our first speaker in this panel is Mr. Mohammed Sheikh Ali, who is the managing partner for Rasa Concilium Lahore, and he will be sharing his thoughts on the legal frameworks governing energy disputes by examining international laws and treaties that govern energy disputes and how their applications are proceeded. Our second speaker in this panel is Mr. Ayan Memon, who's a partner at Abid S. Zubairi and Ayan Memon Law Associates, and he will be sharing his thoughts on the future trends in energy disputes, Pakistan in a power play position. Our next speaker in this panel is Mr. Qasim Wadood, who's a partner at Legal Oracles, who will be discussing and sharing his thoughts on the case laws from around the world and lessons for Pakistan. Our second last speaker in this panel is Mr. Shahid Ali Khan, who is an advocate of the High Court, Muzaffargarh, and he will be sharing his thoughts on the creating a conducive environment for globally funded projects in Pakistan and non-performance of banking sector in certain areas. Our last speaker in this panel is Mr. Honorable Justice Zulfikar Ahmed Khan of the Sindh High Court, who will be sharing his thoughts on navigating energy disputes in Pakistan.
Well, thank you very much indeed. I appreciate we're having a coffee break. I hope this is going to be a thrilling discussion. So we are planning on having a true panel discussion, with the exception of a few individuals who will do a presentation. The idea is to really allow for some healthy engagement around the room. So I do hope that those of you that are participating, that are present, will jot down some questions and then ask them a little bit later, and there will be an opportunity for answering questions. But first of all, allow me to extend thanks and appreciation to the organizers of this beautiful event. To Mian Shiraz, thank you so much for the invitation. It was very gracious indeed. It's great to be back in Pakistan. Second time, but first time in Karachi, and truly great honor, great privilege to meet so many old friends and to make so many new friends. But without further ado, we have an exquisite panel and a thrilling discussion. Panel number 2 today will be focusing on the power play, the dynamics of international energy, power, and gas disputes, with a special focus not only on litigation, but on ADR. So I will commence with some questions to our panelists. And if I may, given that you are to my left, Sheikh Mohammed Ali, I shall start with you. And none of these individuals need any further introduction. They are all known to you. So Sheikh Mohammed Ali, if I may start by looking at the legal framework, could you give us some insight in international treaties relating to the energy sector that Pakistan is a signatory to?
Thank you very much. There is only one international treaty which is known as Energy Charter Treaty, and which was lastly amended and revised and then consolidated in 2015. But Pakistan is not a signatory to that treaty or any other treaty on energy laws. Pakistan has signed general international contracts, bilateral contracts, foreign direct investment, and even the arbitration rules, for example, the conventions related to arbitration, for example, New York Convention, we are signatory to that, and we have ratified them as well. In Pakistan, these issues are generally dealt with under the terms of the contract, which is known as Power Purchase Agreement, or the Gas Supply Agreement, or Fuel Supply Agreement. So these contracts basically govern the disputes, and the terms accordingly are settled between the parties. They select a governing law to deal with their basic substantive disputes and the terms of the contract, and then in the arbitration clauses, which we can call as arbitration agreement, they also select the law applicable for the resolution of their arbitral disputes, as well as the procedural law to govern the procedure of the arbitration. One such example is the selection of LCIA rules these days, and earlier it was the selection of ICC rules, under which Pakistan had referred the matter to the arbitrations at the international level. The example under which Pakistan underwent the arbitrations at the international level, but under the general rules, for example, the case of Karke Karadenize, where the dispute emerged from the rental power contract, and that was eventually turned into an interstate dispute and was filed under exit, and then was decided accordingly. So that is how this basic scheme of law and the contracts and international conventions govern these things.
Well, thank you very much. I think you've touched upon a number of very pertinent points. And one of the points that you did make is that there's been a shift from, or a policy shift away from integrating exit rules or ICC rules towards, I believe, LCIA and UN Citral arbitration rules. Why do you think that is?
Well, that is because of the different power policies. Pakistan promulgated its first known power policy in 1994, which is called the Power Policy in 1994. And then we gave a policy in 2002. That the first power policy, which came in 1994, was basically targeted to engage the direct foreign investment. So being the FDI and being expected, there was state disputes could have been there. So at that stage in time, the contract was drafted to say that any arbitration would be taken under the exit rules. And in case an award would not be enforceable, then it would be under the ICC rules. Subsequently, in 2002, when Pakistan decided and the government said in a policy that the local indigenous fuel would be preferred and the investor from Pakistan would be given the priority, I still remember the Secretary to the Ministry of Water and Power, as it was at that time, he said, we had brought back the arbitration to Pakistan. And for that, they selected the LCIA rules in the first instance, and if that application of those rules would not result in an enforceable award, then they decided that it would be under the United Nations Citral rules, UNCITRAL rules. So that is how there is a shift apparently because of the policy change at the back.
Thank you, and still with you, if I may. So we hear that there is a shift in favor of arbitration.
Yeah.
Do you have any comments on that particular shift in the policy of Pakistan when it comes to resolving energy disputes?
All the disputes in Pakistan under the energy contracts are basically three stages. The first stage is that the parties have been advised to go for negotiation, which is a level between the chief executives. They have to sit within a given time period in order to attempt for a resolution and to avoid the dispute from being before the mediators, experts, or the arbitrators. If that stage fails, then as a second step, there was a provision under the 1994 power policy, those power purchase agreements which were signed under under that policy, to mediate by an expert. That provision for mediation was replaced with a new provision under the power purchase agreements. Those were executed under the power policy 2002. And the new provisions say determination by the expert. So there is a shift from the mediation to the determination by expert. And if even that stage fails, then as a final stage, there is the provision which says now you have to arbitrate, and there is a timeline in which you have to take the matter to the arbitrator.
Great. Well, expert determination followed by arbitration, the way to go. Good. Thank you so much. I'll come back to you in a while. So we've heard about the current legal framework and the power policy in place in Pakistan and the changes over the years. That was incredibly insightful. I am grateful. If we can then move on to Kasim. So Kasim, you've got a great deal of experience. I know you're a little bit further down the panel. You've got a great deal of experience on ground, particularly when it comes to cases that you've been involved in. But could I ask you to start off by commenting on recent trends in dispute resolution practices in Pakistan, in the relevant sectors, so energy, power, gas?
So, thank you, Leonora. Primarily in Pakistan, the recent trends, and when I say recent trends, I'm talking the last 4 or 5 years, is primarily of two categories. One where the dispute is actually raised by the upstream power sector or even energy sector entities. Process, primarily how we've been dealing with it, is that the arbitration system, which is actually raised, takes it to primarily exit, and thereby an award comes in. Once the award comes in, what trend recently been developed is after the award, the government negotiates based on the ceiling that comes in from the award to something which settles either the amount in kind or reduce the amount itself. That's trend one. We've seen it in Karke, we've seen it in Ricodic, as mentioned by Chopa Saab in the last session. We've seen it in many other arbitrations that are, many other settlements that went ahead in the same process. There are a few that I'm working on with the government right now, and they are also in the same line of, let's say, dispute resolution. So primarily, there is a ceiling out there, and that ceiling is somewhat reduced in a negotiation or negotiated settlement. And that process aside, the second group of, or let's say the kind of negotiation that is taking place in the last few years with the power producers is the somewhat renegotiations of contracts. Pakistan in 2020 went ahead and renegotiated with the IPPs, almost 47 of them renegotiated their contracts. I was part of the negotiation team in that process. Unfortunately, or fortunately, the processes that we used in that negotiation was the old way of negotiation, which is a win-lose format of negotiation. And that particular category, which is primarily called the distributive negotiation form, that gives the incentive only to one party and not to the other. So the process of the recent form of negotiations, which is called the principal negotiation, which is getting more substance around the globe, we've not yet achieved that category. So primarily in both the scenarios, what is common is that the government of Pakistan either negotiates based on a ceiling downwards, or primarily converting it into services rather than payment in kind, or negotiate a win-lose contract whereby you renegotiate the terms of a contract that you should have primarily negotiated in the first go. The basic theme or basic reason for that, what I've realized in these processes, and I was part of these processes in the last 4 or 5 years, is the anti-graft laws of Pakistan. So when it is public sector negotiating with the government negotiating with the producers, it is always seen in the light of future investigations that may entail very, very rigorous and long punitive criminal investigations. And I know of certain individuals in the government sector who are facing anti-graft laws and investigations for 16 years at least. So that's the process why we are having this impediment where we cannot go into the modern form of negotiations, where we preempt a dispute and resolve it. Rather, we exhaust the remedies in terms of an adjudicated form, and then kind of resolve the matter.
Thank you, Kasim. Let me jump in there, and I'm going to try and be a little bit louder. I apologize if some people at the back of the room did not hear me earlier. So you make some very interesting points about the power granted, certainly to officials in the public sector, to negotiate freely. And I think we will agree that when you're looking at negotiation, the ideal position to be in is to have a win-win or a lose-lose situation, so that both parties are equally pleased or displeased with those negotiations and the outcome that they have arrived at. But pray tell, let's hear your views on whether we find ourselves in a situation that there is over-regularization that prohibits or perhaps does not allow for sufficient discretion, authority, and power to make a call when it comes to these negotiations conducted with public entities and officials.
So first, I'd like to kind of discuss the term over-regulation. Now, over-regulation itself is a relative term. One might or might not consider the power sector at this given moment over-regulated, rightly regulated, or under-regulated. What we can actually see is how the regulator is acting, and whether the regulator is acting maturely or immaturely based on the regulations that are available to it. The main regulator in the power sector is NEPRA. And what I see is that ever since its inception, since 1997, it is somewhat in the learning phase. So it is still learning how to regulate the power sector. And this learning has cost us many litigations and many, let's say, adverse outcomes. Now, I've also seen that the regulator is regulating in somewhat in a pendulum form. So sometimes it is over-vigilant, and sometimes it is under-vigilant. And this process of inconsistency also leaves a lot of space for manipulation in terms of the regulatees. So, as far as over-regulations are concerned, I think the major issue for the regulator right now is consistency in its approach towards how it wants to regulate, how much it wants to regulate, and in what sphere it should be regulating. So one recent example would be the new coal industry that was coming up. Now, the regulator in the beginning was extremely lenient in terms of coal buying, and then immediately it went from extreme leniency to extreme regulatory vigilance over coal buying. Now, there has to be some middle ground in the extreme leniency and the extreme vigilance, and that is what needs to be achieved in terms of regulations. And that also brings us to the second point in the over-regulation sphere, and that is the relationship of the regulator with the policymakers. Now, primarily the regulator was brought in to regulate the pricing of power sector in the rational manner, so that it takes away burden from the policy makers to either satisfy or dissatisfy its voters. that role has somewhat reversed now. So at this given moment, policymakers, due to IMF pressure or whatever, are more rational in their approach towards pricing than the regulator who was supposed to be doing that. So what I'm trying to say, come at is there is this maturity required in by the regulator rather than more regulations or under regulations for that matter.
That's a very interesting observation, particularly interesting to hear that you feel that a lot of the time the regulators are reactionary and it's more about forward planning and seeing what is happening on ground, what is happening within our circles, and looking at addressing that at an opportune time. Now, in terms of the regulation, you've also described what is potentially a conflict in views between different stakeholders involved. So it's really good to have a communion and harmony between those various stakeholders when it comes to decision making, certainly drafting new policies that will inform the future trend and the future norm. But what was particularly interesting in our discussion is your experience, and you've had the rare pleasure to experience the resolution of complex disputes in this particular field and sector by having effective negotiation and negotiation techniques utilized around the table, and individuals authorized to play the game in accordance with those rules from all around the table. And it does take a true communion between all those individuals to arrive at a successful outcome. So from your point of view, before we move on to the next individual, I'm very keen to hear what changes, if any, you consider would be helpful to facilitate alternative models of dispute resolution being brought in to this sector.
So I have 2 or 3 suggestions in that. Primarily, the first and foremost, the major issue in the form of dispute resolution that we are undertaking right now, I've come to this conclusion that with the anti-graft laws that are there existing, there will always be either a win-lose form of negotiation coming up, or we will be negotiating a ceiling which is never a good thing in terms of we would already have lost an arbitration. Now, to do that, we either need to define the process in which the government functionaries take up the decision to negotiate or not to negotiate. And that can be done either by bringing in legislative measures or judiciary defining good faith. And it's not just defining good faith, but also protecting good faith in that regard. Once that is done, only then public functionaries would venture into resolving disputes preemptively rather than reactionary. In addition to that, what I believe is that, especially my experience with in negotiations with the IPPs, I believe that a state or a country should not renegotiate contracts based on bad bargains in the beginning. So if the country has made a bad bargain, that should not be a ground for renegotiating contracts. That's not how states react. States should only negotiate contracts if there are flaws in the contract or manipulatory procedures that are undertaken by the, let's say, the regulatees. And that's the second, let's say, suggestion that I would be giving.
Thank you ever so much. I'm just going to come back to Sheikh Mohammed very briefly. to speak about his experience in arbitration and energy, and then we will move on to looking at another sector, which I find is fascinating, which will be the power sector. So Sheikh Mahmood.
Yeah. I have been in LCI arbitrations, ICC arbitrations, represented the government of Pakistan, state-owned entities there. My precise experience is that at the stage of negotiation, the most fearsome thing for the party, government officers, is the accountability issue. I remember I was in negotiation with KAKE. I was representing the government entity called CPPA. And at that stage in time, the officers were only in fear that what will happen thereafter. So that is the first issue. Because of that issue, so many things which could have been settled at the initial level could not have been. And while going into the arbitrations there before the international forums, the problem remains that some petty issues were also there. So my personal experience going with Wadud, the regulator has introduced the regulations like in OGRA and NEPRA, both they have, to resolve the disputes between the licensees. My suggestion shall be that they must also bring some regulations by which they could decide the petty issues at their own level, so that the accountability fear could be circumvented. Thank you.
Thank you so much. Good. Well, let me then move on to Ayman. So Ayman, we've spent a fair bit of time looking at the framework in place in Pakistan, looking at the shift in policy, certainly when it comes to the adoption of arbitration rules. We've also looked at experience on ground by esteemed practitioners that have been involved in arbitration cases in the energy sector and negotiations, and very tough negotiations in the energy sector. I would like to come to you now and to ask you about the type of disputes and certainly your own experiences in the power sector. And I appreciate that you've got a huge amount of experience in gas and electricity. So if we can focus on those areas, please.
Honorable judges, learned friends and colleagues, good afternoon. So, taking on from your question, I think there's been a lot of focus on upstream issues, upstream contracts, and how arbitrations and mediations and negotiations are a good form of dispute resolution mechanisms there. Now, those are issues, naturally, there's a similar bargaining power when these contracts are being entered into and the parties opt for arbitration as a preferred method. There are international arbitrations, and certainly we'd like to see more local arbitrations as and when that system is formalized in Pakistan with specific rules, and because a lot of confusion with ad hoc arbitrations today is that an arbitration clause would provide for appointment of an arbitrator, but the arbitrator would not know what rules to follow, whether evidence is to be recorded and so on and so forth. But leaving that aside, the vast majority of energy sector disputes that come to the courts are between the end consumer and a supplier. Now, this happens in the case of power distribution companies, the DISCOs, and also in the cases of OGRA licensees, so who are providing natural gas to the consumers. Now, up till 2018, there was no alternative method of dispute resolution when it came to electricity matters. So if anyone had an issue, they would go to a court and they'd try to get their grievance agitated. The only exception was that in the Electricity Act of 1910, for a billing dispute, a person could approach a provincial authority called an electric inspector. Naturally, the awareness wasn't there. A lot of people would not know that they have to approach there, and they'd end up approaching the courts, and their cases would be returned on the ground that you have to go there and you have to get it resolved, and they have the technical expertise. When the NEPRA Act came in, NEPRA as a regulator had the power to entertain complaints of all types of disputes. So if a consumer has a billing dispute, it has a dispute in relation to a tariff that NEPRA has issued, all those disputes can be taken over to NEPRA under the relevant provision, which is Section 39. Now, what happened was that once NEPRA had made a determination, there was no avenue for the consumer. So a consumer or in fact a licensee would then approach the courts either in the writ jurisdiction or the original side, and they'd agitate their grievance. Now, some of the disputes, naturally, they would involve a question of law, but a lot of them were very highly technical issues. And when it pertained to tariffs, there was a lot of finance involved. In 2018, the NEPRA Appellate Tribunal was formed. And the appellate tribunal is to comprise of a chairman, who is to be a retired judge of the High Court, a person with a financial background, so a finance member, and a technical member, preferably an electronic engineer. In 2018, even though the law came in, the federal government did not appoint the tribunal. And it was in 2020 that the Supreme Court, in a suo motu action, had to direct the government to appoint the tribunal. The tribunal was appointed, but till today, there's no member finance in the tribunal. So there's literally no expertise. Now,
let me stop you there. So you've just outlined what is a very real difficulty and a challenge that needs to be overcome. How would you suggest that we overcome that in Pakistan?
I mean, I think this amendment in the law is a very good amendment. It's a welcome change because you have created a specialized tribunal, but there has to be seriousness from the government side as well. We need qualified people on the tribunal. When people now go to the courts, naturally they're turned down. There's a recent judgment of the Supreme Court which says that in these technical disputes, we're not going to intervene. But the alternative, the dispute resolution mechanism, has to be proper. Although there is an appeal provided to the High Court, and I'm sure a lot of appeals would come in if those members are not properly appointed and the determinations are not correct, I think that is the right way to go. But you see, there are other types of disputes. Small billing disputes, less than 200,000 rupees. People are coming to the courts in the writ jurisdiction, they're trying to get their bills corrected, and that creates a lot of burden on the courts. Now, NEPRA under Section 39 can entertain those complaints, but unfortunately, it's based in Islamabad. There is no regional office in the different regions. A person sitting in Ghotki, if he has a dispute with his disco, how will he approach NEPRA? There are no timelines provided how the complaint is going to be resolved. That person ultimately would end up in a civil court, which is right there. Even if he goes to a lawyer, the lawyer can't go to Islamabad because for such a small dispute, the traveling cost alone would be higher than the disputed amount. So these are things that need to be worked at. There are certainly good alternative dispute resolution mechanisms provided under the law, but we need to implement those laws, and the government needs to be serious. The third type of issues, and this is something that in the recent past, what I've seen is that a lot of disputes arise from a tariff issued by NEPRA or a determination given by OGRA in gas disputes. And the dispute primarily arises because of a government policy to either reduce a subsidy which was being given or on the basis of a policy guideline issued by the government. Now, these authorities claim that they are bound by these government guidelines. And once that is incorporated, under the gas disputes, naturally there is no other avenue for them to go. They have to go to the courts. Currently, there is no other dispute resolution mechanism. If there's a billing issue, a bill correction issue, or in relation of terms and conditions, there are regulations of 2003 and they can approach OGRA. But for a matter where a subsidy is involved, so a government policy mandated subsidy is involved, there is no avenue in gas. And as far as electricity is concerned, that tribunal needs to be functional properly, and there have to be timelines when these disputes are decided, because the entire industry, if they are going to export goods abroad, if they're going to compete with international markets, they first of all need certainty, and secondly, if that certainty is not there, a decision has been passed, it needs to be decided very quickly, so that we as a country can compete internationally as well, and these alternative dispute resolution mechanisms are properly implemented in that way.
Thank you. So I would agree, we're looking at cost-effective resolutions. And now we've got some other issues surrounding geography and access. We've also got the issue that was raised by one of the individuals who asked a question a bit earlier today regarding resourcing, and that's also very pertinent issue and a live issue for a number of people sitting in this room and elsewhere. Now, allow me then to move on. I have been reminded that we are running out of time. The discussions are just so thrilling. I could go on all day. But let's now move on to Shahid, and if we've got time, we will come back to other panel members. So Shahid, you are a banking expert, and we are very pleased to have you with us today to discuss not only your views from the banking perspective, but also looking at risk mitigation issues.
Ladies and gentlemen, from the taking advantages of yesterday's discussion and from the advantages of you all people, the non-performing portfolio of the banks, how we will settle these portfolio through ADR. Ladies and gentlemen, we have yesterday discussed about direct investments, FDIs, LDIs, and investment of CPEX, and whatsoever GDP growth and etc. But you cannot imagine what is the position of non-performing loan in Pakistan banking sector. Ladies and gentlemen, according to a State Bank of Pakistan report of 23rd April 2024, published in the Daily Dawn on 24th April 2024, the bad loan figures is rupees 994 billion, say 1,000 billion, and major part of the NPL is in textile sector. Textile sector shows 182 billion in non-performing loan, and the private sector borrowing during 2023 is only rupees 208 billion, whereas it was 1329 billion in 2022. Agri sector default is 65.9 billion and auto sector is 19.3 billion. Here I may quote Mr. Alan Greenspan, President Federal Reserve Board. He once again said, "We should not forget that the basic economic function of these regulated entities, that is banks, is to take risk. If we minimize risk in order to reduce rate to zero, we will be, by definition, have eliminated the purpose of banking system." Unquote. From these words of Mr. Alan Greenspan, we ascertain that risk cannot be eliminated and risks are always be there. The difference between risk mitigation and non-elimination is the portion which can be termed as NPL, non-performing loan. This NPL leads to a cumbersome recovery process, litigation, and so on and so forth, ignoring the cost plus benefit of NPL and litigation processes. Ladies and gentlemen, while financial institutions are facing multitude causes and reasons for these problems, but it is directly related to lax credit standard for borrowing, portfolio risk management, or lack of attention to changes in the economic and other circumstances that can lead to deterioration in the credit portfolio of the banking sector. While a number of ways and means are available and also introduced and required by the regulators both national and international. Most of you people know international regulators. To overcome the deterioration in credit portfolio, even then, bad debts are inevitable in lending business. No matter how careful we are, there may be situation when banks should declare bad debts. Often the borrower may face unforeseen circumstances for which they may not be able to pay even though they have good financial records. In any case, you will always want to recover the loan as much as possible at as little effort as possible. In order to strengthen their credit risk management, banks are required to establishing an appropriate credit risk management environment, operating under a sound credit granting process, maintaining an appropriate credit administration and measurement and monitoring process, ensuring adequate control over risk. Finally, the role of supervisors is important. Senior management should have responsibility for implementing the credit risk strategy approved by the board of directors. Despite all these efforts, which banks are required to carry out by regulators, this deterioration situation is hampering the overall economic growth, GDP, loss to national exchequer, and huge amount of NPL to the tune of rupees 994.82 billion, say now, as of 31st December 2023, now it comes to approximately 1,000 billion.
Thank you, Shahid. I heard you say that one of the issues is over-regularization in the banking sector. And correct me if I'm wrong, the case here is that ADR has placed
Yes,
a
madam,
feature
I am going to ADR.
in helping to streamline
Yes, ma'am.
disputes.
Yes, ma'am.
Can we just have concluding remarks? I'm sorry, but we're running out of time.
Okay. Two processes are there. The judicial process, obviously everybody knows, the courts and banking courts, etc., and non-judicial. Non-judicial is restructuring of loan repayment, of pushing back of installments, and settling or haircut settlement, or corporate restructuring of the borrowers, you may know, and bailout packages, write-offs, etc. Now I am suggesting, why should not we refer all these cases to the ADR processes? Lord Jackson said that ADR process is cost effective, and it bears lesser costs. Parties should be encouraged to settle their disputes before resorting to the courts, or if otherwise they are in the courts at early stage of the litigation, they must settle their cases. I propose that yesterday Ms. Hea proposed to depute mediators in district headquarters. Now I propose that technical mediators, technically, for settlement of bank cases, the mediator must be technical. Technical mediators should be posted by the consent of the regulators at divisional headquarters, and park number of cases to mediators for early settlement, and so that the huge amount of 100 billion may become unclassified and regularized. Thank you.
Thank you, Shahid. So we've talked about negotiation, moved on to arbitration, and finally mediation. That's really music to my ears, because I'm a huge advocate of all those methods of alternative dispute resolution. And last but by no means least, we have His Honourable Mr. Justice Zulfikar Ahmed Khan with us, and I'm pleased to have him on this panel to be providing a view from the judiciary.
Honorable Mr. Justice, retired Judge of the Honorable Supreme Court, Justice Samad Jalal Usmani Saab. Honorable Mr. Justice, retired Mushir Alam Saab, the Judge of the Honorable Supreme Court. Mr. Justice Shafi Siddiqui Saab, Senior Puisne Judge of the High Court of Sindh. My brothers from the High Courts in KPK, Balochistan, Punjab, Islamabad, Gilgit-Baltistan, Barrister Mia Shiraz Saab. Ladies and gentlemen, Assalamu alaikum. It's always a pleasure to stand before you and such an august gathering, and as we have been highly induced by the knowledge of the last many speakers, I had taken the trouble to put out, first of all, the Pakistan's energy map so that we can see what are the issues and what are the disputes that arises and how can they be minimized, and what do we need to do to resolve them? I'm sorry you can't see that, or because this TV is not working. The Pakistan's overall energy needs, as they stand sometime in the year 2022, are comprised of the fossil fuels, which are coal, oil, gas, electricity, which is mostly generated by fossil fuels, except very little from the nuclear energies, and the biomass. The fossil fuels, as you can see from this point down, probably constitute about 70% of our energy needs. The rest comes from the biomass, which is animal waste, crop waste, and very interestingly, this whole chunk, which comprises of nearly 30% of the Pakistan's energy need, is in completely informal sector. And this being in informal sector, you can see that so far, I have not come across any disputes arising in this sector because it's been completely regulated, mediated, resolved by the players themselves. The entire bulk of legal disputes is in this range, which is 70% and coming out of the highly regulated industry, which is be the coal, be the oil, the gas, or the electricity. So we will see that how it is that the more you start regulating a process, the how many number of disputes arise in that area. So we'll go one by one. No, I won't take much of the time. So the coal disputes are primarily with regard to mining and lease disputes, the import disputes that these courts are mostly interested with, storage disputes, which are primarily the environmental concerns related to coal. And our courts normally have these three kinds of disputes. And I do not, the coal authority is the body that regulates the import of coals. There's a coal mine rules recently promulgated, and there's a Coal Authority Act available. But there's no provision of arbitration, mediation, or dispute resolution as far as the coal is concerned. And coal not forming much of the energy needs is not really much discussed here. ONG is the main sector. We'll come to electricity, where the large number of disputes arise. Is oil and gas is the sector which is highly regulated by OGRA. And our courts, and I think all the courts, even the Supreme Court, are always have to decide many cases pertaining to oil and gas sectors. Only last month, the ICC upheld Pakistan's jurisdiction over a dispute with regard to oil exploration and oil sector. One of the trouble that facing the entire oil gas sector, as well as the electricity sector, is the government sector debts and dues that they need to pay. ONG itself requires government to pay 1.5 trillion rupees to clear its debts off. The disputes in oil and gas also that comes to the courts are with regard to tariff. We're always, because the mechanism by OGRA is I would say such a cumbersome process. Even being a lawyer, being an engineer, being a judge, it's very, very difficult to even understand the methodology and the complex equations that form how. In one of my judgments, I actually tried to copy a judgment, tried to copy an equation which probably have differential equations in it, which probably judges or not, even arbitrators or mediators can't understand probably, unless they have very strong math skills. The other disputes that come to us before the courts are generation disputes and the supply disputes, which are, again, the OGRA uses its, I would say, highly regulated monopoly to fix prices, the gas supply prices, in various parts of the country at various different rates. So there's always a disbalance between the tariff available. In ONG, the reason that the delays cause oil and gas exploration company is that because the disputes are not resolved. No ONG company would like to invest, where the disputes are still handling, and the government somehow so far has no mechanism to mediate these disputes, arbitrate these disputes. This is one of the clip from the newspaper. Now coming to the power disputes, which is probably the area we're all, at least in the urban part of the country, is a very interesting that in the last, how the landscape has changed over the last 4 or 5 years, for example. In the year 2015, the electric producing companies, if you look into this chart, it's primarily comprised of 2 blocks, that green blocks and the blue block. These middle bands are nearly similar, so in this interest of time, I will not discuss this. But if you look into the blue block, there's the energy charge. That is the cost of nearly producing the energy. This is the cost of using the system. This is transmission and distribution losses. This is the distributor's margin. This is last year's adjustments. But the most important element here, as you see, is the capacity charge. The capacity charge is the recurring debt. And if you see this graph from the year 2015 to 2022, this green block is inflating like a balloon. Today, Pakistan's 5% of the GNP, which is about 5.5 trillion rupees, is stuck in this green block. And you see how it is changing over the years, and these are those IPPs and other government subsidies that are not paid and keep on adding to the cost of the service. This balloon is very, very important to keep in mind, that if we can resolve this, and this amounts to, between the last, every day, there is about like more than 200 billion rupees added to this green block. In the last 2 days, we've added 5 billion rupees as a circular debt within the country's power supply sector. So how important is this? And this is where we might have dispute resolution adjudication probably in this sector, but the biggest sector is this, for which we do not have any sectors, so except the negotiations which were going on, but obviously not much help so far. NEPRA is the regulatory authority that is responsible to award licenses, have tariff determination, consumer complaints, overall regulation, and disputes regulation is a part of the NEPRA's law, has now been built to this round. But a lot of the work that the courts are busy with are in these 3 sectors. Licenses, tariff takes a lot of our time, and most of the judgments you will see arising from all the high courts and even the Supreme Court are coming on these tariff sides, because as I said, the complicated formula to determine tariff is nobody can understand except those there at the helm of the affairs. And why do we have that? Such a complicated formula is just obviously best known to them. This is Pakistan's dispute summary for the last 10 years. We had actually UNDAC. We have 3 disputes that went to UNCTAD, and in the last 10 years, I think more than 12 disputes have overall gone, which the latest is being with Turkey and Saudi Arabia. What's the future? Coming have been shown this time. I think the biggest challenge with us is the resource development. I think each and every speaker has emphasized this. And the resource development of lawyers to deal with international disputes. What happened at Kake, what happened with Yadev Kalboshan, is just all known to us. That this $5 billion that we had to pay is again an act that could have been avoided by bringing in lawyers, bringing in good resources. Behind all of this, the lady from the World Bank raised a very innocent question: why it takes 15 days to list out a person on the list to have a dispute? This is the word for it. They will take, every player is playing with his names, with his numbers, who want to be listed on that list. So if 15 days takes place, I think, which probably, considering the circumstances, is not that bad. Modern laws, we need to modernize. We still have the Electricity Act of 1911 or something, when electricity was invented actually by whatever. So we still have that. Most important thing that we find is that missing in the government sector is the beneficial interpretation. They think they're ruling a different country. The people, the consumers, are aliens to them. There's no concept of beneficial interpretation. If there could have been beneficial interpretation at the original side, these such disputes will never arise. As we just started the renewable energy resources, the more and more we go into that, we will be solving a lot of the energy disputes. The UK case is that there's an energy ombudsman. So we can have an ombudsman available in the energy sector. So the biggest trouble, again, before I conclude with that and leave to thought, is that in the country, there are probably, I was listing now, there are more than 10 regulators. NADRA is a regulator, PIPRA, and all these are all regulators, the electricity regulator, NEPRA. Whenever you have a regulator, the biggest question posed is that who regulates the regulator? Are regulators independent, divine entities that cannot be challenged? No. Every country with our regulators, there are who regulates the regulators is important. Here we just go, every decision from the regulator comes for the challenge.
Thank you so much indeed. Thank you so much. I appreciate that we are stuck between the coffee break and lunch. I am grateful to all of you. I am truly grateful to our fabulous panel. It's been such an insightful discussion. I hope you've enjoyed it as much as I have. By all means, do continue the discussion in your own time. Thank you to all of you, gentlemen.